Today, we're going to look into the Mental Capacity Act 2005. Before we delve into the specifics, let's understand what this act is all about. The Mental Capacity Act 2005 is a UK law that provides a crucial framework for acting and making decisions on behalf of adults who lack the ability to make particular decisions for themselves. The Act's primary objective? To empower and protect these individuals. It ensures that they are involved in decisions about their care and treatment as much as possible. Now that we've set the stage with a general understanding of the Act, let's delve further into its specifics. Now, you may ask, who exactly does the Mental Capacity Act protect? Well, this Act doesn't discriminate. It embraces a broad spectrum of individuals who might find themselves unable to make certain decisions due to various circumstances affecting their mental state. This includes those facing the challenges of dementia, grappling with learning disabilities, or dealing with mental health problems. It's not only for those with long-term conditions, but also for individuals who might find themselves temporarily unable to make decisions. This could be due to a stroke or head injuries, or even transient confusion. Even someone under the influence of alcohol or drugs, who might not be able to make informed decisions at a certain time, falls under the protection of this Act. The Act acknowledges that mental capacity isn't a constant state. It can fluctuate and vary from person to person, situation to situation. Therefore, it is a comprehensive Act that covers a wide range of individuals and situations. How does one assess someone's mental capacity, you may ask? Well, it's not as straightforward as it may seem. The Mental Capacity Act 2005 prescribes a two-stage functional test. The first stage is to determine if there is an impairment of or disturbance in the functioning of a person's mind or brain. This could be due to a variety of reasons, from conditions like dementia or severe learning difficulties, to the effects of a stroke or brain injury, or even the symptoms of intoxication. If such an impairment or disturbance is confirmed, we move to the second stage. Here, we assess if this impairment or disturbance means the person is unable to make a specific decision when they need to. This could be due to an inability to understand, retain, weigh up information relevant to the decision, and an inability to communicate their decision. It's not a simple yes or no question, but a process to ensure fair and accurate assessment. Let's now delve into the role of an independent mental capacity advocate, or IMCA, in the Mental Capacity Act 2005. You see, an IMCA is a safeguard for people who lack the capacity to make some important decisions. These advocates provide support and representation for the person who lacks capacity, especially when the person has no one else to support them. Picture this. A person who is unable to make decisions due to a mental impairment, with no family or friends to help them navigate through the complex processes. This is where an IMCA steps in. They play a crucial role in the decision-making process, ensuring that the person's rights and interests are upheld. They ensure that the person's voice is heard, their rights are respected, and that decisions made are in their best interest. So, remember, an IMCA plays a vital role in ensuring fair and unbiased decision-making under the Mental Capacity Act 2005. They are the champions of the voiceless, a beacon of support in a challenging process. Have you heard about deprivation of liberty safeguards, or DOLS? Well, they're an essential part of the Mental Capacity Act of 2005. They come into play when there's a need to provide care or treatment to someone who lacks the mental capacity to make decisions for themselves. But here's the catch. This care or treatment may require depriving them of some personal freedoms. Now, you might be thinking, that sounds scary. But don't worry, these safeguards are here to ensure that any such steps are taken responsibly and ethically. They are not about taking away rights, but about protecting individuals who cannot protect themselves. These safeguards apply to situations like hospital stays or living in a care home. They ensure that any deprivation of liberty is assessed meticulously, is only done when it's in the person's best interest, and is regularly reviewed. So, remember, these safeguards ensure that a person's freedom is only infringed upon when absolutely necessary for their safety. What role do care homes play in this act? Well, they shoulder an immense responsibility. care homes are obligated to comply with the Mental Capacity Act 2005. But what does this compliance look like? It begins with an assumption that every individual has the capacity to make their own decisions. This is a fundamental right, and care homes must respect it. But what if there's doubt? In these cases, care homes are required to prove otherwise. This is not a task taken lightly. It involves careful assessment and a deep understanding of the individual's condition. In addition, care homes also have a duty to assist individuals in making their own decisions. All practicable steps should be taken to support this process. This may involve adapting communication methods or providing additional support and education. In essence, care homes are on the front lines, ensuring the Mental Capacity Act 2005 is upheld. They ensure rights are protected, voices are heard, and individual autonomy is respected. And that's how care homes play a pivotal role in upholding the Mental Capacity Act 2005. Now that we've learned about the Mental Capacity Act 2005 and its implications, it's time to take your engagement to the next level. If you found this content beneficial, don't forget to subscribe to our channel, give this video a thumbs up, and share it with those who could benefit from it. Your support helps us continue to provide informative content like this. So don't hesitate to hit that subscribe button, like this video. Thanks for watching.